That's 877-850-8585. Now here's your host, Attorney Jeff Vastola.
Well, good morning, everybody, and thank you so much for tuning in. This is yet another edition of Vastola on the Law, and I am your host, Jeff Vastola. I'm an attorney. I've been an attorney in Florida for 25 years now. This year will be 25 in October. And I'm here every Saturday morning to give you free legal advice. I always have topics planned. I read through my Florida Law Weekly publication, and I'll have some cases to talk about in there if I have time. But most importantly, we give priority to those people that call into the show. You just heard the number. It's 877-850-8585. Or if you are watching on Facebook Live, which you can do if you are a friend of mine on Facebook, you can type in a question and I will do my best to read it and respond to you. If I miss that question on Facebook Live, I know I've talked about this before, they tend to scroll up awfully fast. So if I miss your question on Facebook Live, the best thing to do is call me after the show to say, hey Jeff, what do you think about this? And I will be happy to answer your question as best I can. And depending on how interesting it may be, it could be a topic of the show the following week. That's what happened with a longtime listener, Don, who called with a question about a traffic stop. And so that ended up being a topic of the day. And as a matter of fact, I'm going to be following up on that again because of a case that just came out in the Florida Law Weekly. My beautiful wife is joining us this morning by Facebook Live. Good morning. Not too far away from me in the kitchen. Apologize for last week's programming. If you were trying to listen to the show on the radio, I was down in the Keys, and unfortunately the internet connection that I used to publish this on the radio show just wasn't strong enough. So we had to play a replay last week on the radio. Those of you that watch on Facebook Live, I got a lot of feedback about the background that was not fake. I was down in Isla Mirada, and those trees behind me were real. It was a very nice setting. And unfortunately, today I'm back at home. So we've got some interesting things going on that I wanted to share with you. First of all, this program, whether you listen to the radio show or whether you're watching me on Facebook Live, this is all brought to you by my law firm, which is called Vastola Legal. We have physical office locations now in Palm Beach Gardens, Stewart, and I'm pleased to announce now the Keys, the Florida Keys. We have signed our lease, which is the reason I was down in the Keys last week. Signed our lease, and so we are now official as of April 1. Lease is going to begin April 1. We have physical office space down in Tavernier, which is the middle to upper Keys, they call it. And of course, as always, we represent clients throughout the state of Florida. So if you want to talk to me about any kind of a case that you think I might be interested in taking on your behalf, then call me anytime. Call me at night, call me on the weekend, call me early in the morning, I don't care. The best number to reach me is 833-VASTOLA, which of course is my last name. 833-827-8652. That number forwards to my cell phone. If I don't answer, leave a message and I will call you back. I have heard lately that sometimes the voicemail is filling up and you might get a message to say voicemail is full. I do try to get through that and delete those messages after I've heard them. So if you get that message, then call me back again, several hours later or the next day, whatever it may be, because I do want to hear from you. Obviously, if you have a case that I'm interested in, I do want to represent you. And I want everyone to understand that there are different business models in the world of what we do. And there are ways to attract lots of clients, and there are ways to attract smaller numbers of clients. And our business model at Vastola Legal is to attract a smaller number of clients so that we can give them what we feel is strong, genuine, personal attention. And so that's what we do in my law firm. If you're looking for a lawyer that you will meet with from the get-go, who you will be able to talk to via his cell phone or communicate via email directly with me, and have a lawyer that's very responsive, then that's me. A little bit of self-promotion this morning. I don't do that very often, but here we are. Also, a lot of irons in the fire at the moment. And good morning to everybody on Facebook Live. Terry, I'm going to be talking to your husband about this next topic because a tire giveaway is actually a big part of what we're going to be doing. And good morning, Mom, from Tennessee. My wonderful mother is up there with my sister. Say hello to everybody. We have our first Free Legal Seminar. I think I'm going to call it Vastola Free Legal Seminar. Slated. It's going to be at the Embassy Suites Hotel. It's going to be on April 27th, and everybody's invited. It's a physical appearance kind of a thing, but of course we will be airing it by Facebook Live. So if you're not in the area, then you can of course participate by watching on Facebook Live. But it is finally scheduled. April 27th is our very first free legal seminar. I'm calling it our first one. Understand that I've done this once before, but it was probably 10 to 12 years ago. I did it in conjunction with a television station where I was doing a lot of commercials and things at the time, a lot of public service announcement type stuff. And that seminar was done actually at the television station, and it was great. It was successful. But this time around, I'm doing it completely on my own, doing it at a hotel room, which I'm going to be renting the room myself. We'll be catering with some drinks and snacks or whatever. But the whole idea is to present more free advice. So we'll have a complete agenda. It's going to go from, I think, 1 to 4. The hotel has given us the room for the entire afternoon, so we just have to decide what hours we want to hold it. But please put that on your calendar, and if you are willing to get out these days because of COVID, we will, of course, have all of the COVID protocol in place. So don't worry about that. But if you're willing to come out, we're going to have raffle prizes, which is going to be really cool. And the grand prize of which is going to be this thing. I don't talk about it very often, but it's near and dear to my heart, is giving away a set of tires to somebody that might need them. Now, if you just got brand new tires on your car, then I wouldn't consider you to be a good candidate for my free tire giveaway. But anyone that's traveling on tires that are at the wear bar or less are just incredibly dangerous. And I've handled cases in the past where young people have been killed, unfortunately, because of low tire tread. And so it's kind of a thing with me that I don't like to see that. So what I'm going to do is, first, at this free legal seminar, I'm going to encourage everybody to bring your insurance policies, at least the deck page, the declarations page, so that myself and some other professionals will be able to evaluate your policy for free. Let us help you understand it. If you're not in the world of insurance as a professional, chances are you don't really understand all of those different coverages on your policy, and it's my goal to help you understand those things. Whether it's an automobile policy, a homeowner's policy, a professional general liability policy. You know, if you're a professional and you have a general liability policy and you think that you're covered for certain things, let me look at that for you, because there's a chance that maybe you're not. I've had cases like that where there is no coverage, although the professional thought that he or she was covered. So that's what we're going to be doing, in addition to a planned agenda with people giving presentation. But there'll be breakout sessions so that you can meet with other professionals and get some free legal advice. But at the end, I'll be going out into the parking lot, and with anybody that's interested and wants me to do it, I'll be measuring tread depth on your car. And so we'll put, depending on how many people are out there and who might be in need, put names into a hat, and whoever wins gets a set of tires. Now, of course, there's going to be some caveat language on that. If you're driving a Ferrari and your tires are $2,000 a piece, I'm not going to buy you a set of 4. But I am going to offer a gift certificate for a set of tires from Tequesta Tire. And that's why I mentioned that, Terry, because that's the only place that I buy tires from. So thank you all for watching. I know I'm kind of rambling this morning, and this doesn't really sound like free legal advice. But like I said, I do have a topic planned. I'm going to be talking a little bit about product liability. And the reason why that's my topic of the day is because, as I mentioned before, people that come into my office to talk to me about certain things during the week oftentimes stimulate an idea in my mind as to what I should talk about. And this week I spoke with somebody about a potential product liability claim. I litigate product liability claims. I have several in litigation right now. And people generally don't understand the concept of product liability and how they may have a claim. And so it's one of the reasons I want to talk about it today. That is, of course, unless somebody calls in with a question of their own. If you want to call into the radio station, the number is 877-850-8585. Call in, interrupt me, because I'm not going to stop talking until 8 o'clock. Don't feel like you're being rude if you call in while I'm talking about something. And until then, I'm going to kick off my discussion of product liability in the state of Florida. Now understand, I'm only licensed in the state of Florida. I only know the law in the state of Florida. So if you're watching this program from New York or Tennessee or anywhere else other than Florida, the laws in your state may very well be very different from Florida. So don't just assume that what I'm telling you here in Florida is applicable in your state. Make sure you talk to a lawyer that's licensed where you are if you have real questions about it. So product liability is a very broad term that applies to essentially any kind of a failed product that causes injury. Okay, that's the elements of the cause of action are that you've got essentially a product that failed when it was not supposed to fail, and again, what products are supposed to fail, but that must have led to injury. If you have a failed product but no injury, what I call that in Florida is a no harm, no foul. The injury aspect of a claim is an essential element if you're going to bring a cause of action like this. The only thing that comes to mind in the way of a cause of action where you don't have to show an actual injury is a claim called defamation per se, where if somebody libels or slanders you and it falls into a very small category of defamation, which is they're suggesting that you are a thief, or if you have moral turpitude, if crimes of moral turpitude, then your damages, you have what's called per se damages, meaning you don't actually have to prove them to a jury. The judge will instruct the jury that you have been damaged somehow, and then it's up to the jury to decide what's that worth. In most cases in Florida, if you're going to be bringing any kind of an injury claim or product liability claim or whatever the case may be, you're going to have to show that not only did the product fail, but it caused damage. It can be personal injury damage. It can also be economic damage. It can be my brakes failed and my car was totaled. Now I walked away and I was not hurt, but my car was totaled. And, so you can seek damage in the way of economic damages of your car being totaled, whatever it may be. So, Don, good to see you this morning. I'm going to be following up with our conversation on traffic stops, in this case of State of Florida versus Freddie Parker. This is out of the 5th DCA, which is the Orlando area, so stay tuned for that, Don. But I just briefly wanted to talk about, make sure I've got plenty of time, I do, product liability in Florida and how are the different ways that you can bring these claims. So product liability claims are often referred to as strict liability, which means essentially what the plaintiff has to prove is that the plaintiff was utilizing the product in the manner in which it was supposed to be used, and it failed. And then the burden shifts to the defendant, whoever that may be, we'll talk about that in a moment, to defend the claim, to suggest that the product didn't fail, or there are other very limited defenses to the claim of product liability that they can try to present, or of course what we call affirmative defenses, like the comparative negligence. If a plaintiff is going to suggest that the brakes failed, but come to find out that the plaintiff was driving at 150 miles an hour, well then of course the defense is going to put forth comparative negligence to suggest that it was the plaintiff's negligence that actually caused the incident, or at least a percentage of it. It would be up to the jury at that point to decide how much of the plaintiff's negligence, if any, contributed to the issue. And if it's 100%, well then the plaintiff doesn't recover any money. If it's 50%, then the plaintiff is only going to recover 50% of the actual award. So product liability claims, in addition to being referred to as a strict liability type of claim, typically arise because of a design defect or a manufacturing defect. These are failed products. So a design defect, as the name suggests, is that a product is defective in its actual design. And so if it's in law school, we refer to products as they're talking about a case to case to case to case as widgets. It's just a word that came up in law school and everybody's heard it if they've been. So if you have a widget that is has flaws in its design and they put it on the manufacturing floor and out it goes, and they send out 1,000 of widgets with design defects, well, every time that widget causes injury, there will be or there could be, I should say, a product liability claim for that. Good example, I'm not using the term widget anymore, being vague, but being specific. I think cribs are a good example of a design defect, at least in the past, where the bars were designed to be so far apart that the baby's head could get through. And then, of course, as a baby's moving and can't really control itself, awful things were happening to babies because their head was getting through the slats of the crib. That's an example of a design defect, and that's an example of a product liability claim, assuming that there's some form of injury as a result of that. Now, the alternative to a design defect is a manufacturing defect, and that's where the design is fine, but something happens during the manufacturing of the widget that causes it to be defective. And that could be a failed weld, or it could be that wires were crisscrossed, or you think of any example you want. But we see a lot of problems with manufacturing defects, and I actually have a case right now where we alleged manufacturing defect as opposed to design defect because it had to do with faulty brakes. There was nothing wrong with the brakes as they were designed. The problem was, at the conclusion of the production assembly, the brakes are supposed to be adjusted properly so that they're working. And in this particular case, we're alleging that they were not. So again, there's an example of a case where it's not a design defect, but a manufacturing defect. There are also various claims of product liability for issues of the warranty. You can make allegations of a breach of an implied warranty or a breach of an express warranty based on what the product was, how it's supposed to be used, and what's written within the product itself as to how it's supposed to be used. And so there's the possibility when a product fails that you can bring those claims as well. And lastly, what I wanted to touch on are the warnings claims. With failed products, oftentimes in conjunction to the design defect or the manufacturing defect or the breach of the implied or express warranty claims, you also bring claims for negligent warning or insufficient warning. And that is the materials that accompany the product. If the warnings aren't sufficient, then there are claims in Florida that can be brought for them. And so there are experts, believe it or not, there are experts out there that all that they do are make opinions about the warnings that accompany a product to say, is it satisfactory or is it not? And so good morning to my sister Lee out in Tennessee. Nice to see you this morning. If anybody has any questions.
West Palm.
Who?
Ron from West Palm.
All right, let's talk to Ron from West Palm Beach. And sorry, Facebook Livers, you get up close of my face when I do that.
Yes, good morning, Jeff.
Hey, Ron, how are you?
I'm very well, thank you. How are you doing today?
I'm doing just fine. What's your question, Ron?
So, I have a question about insurance in Florida. So, is it legal for you to post a bond with the state and insure yourself? Self-insure for either vehicle or homeowners or any kind of insurance in Florida, in the state of Florida?
Well, it depends on what context you're talking about. So it sounds to me like perhaps you're talking about an automobile insurance, but let me show you where it is legal to post a bond, and that's in the world of medical providers. The laws were changed back in 2004 in Florida to allow doctors to go bare so that they no longer had to carry insurance coverage. But in lieu of insurance coverage, the law does state that they have to post a bond. So, to protect anybody that they might injure as a result of medical negligence. So that's an area where specifically you can post a bond, but only because the law says you can. Now, in the area of automobile insurance, no, you cannot. Because the Florida statute that governs automobile insurance specifically requires that if you own an operable motor vehicle, you must carry at least two different forms of insurance, and those are personal injury protection and property damage, and there's no exception to that rule. So,
okay. Well, the reason sorry to cut you, but the reason I'm asking this is because I don't know how much you know about the blockchain and how it's evolving and how it's revamping the financial and insurance industry.
I've only heard about it superficially through my sister, who's actually watching on Facebook Live, and she recommended that I start reading a little bit more about it. But I tried to, and that stuff is just way over my head.
Yeah, well, it's the evolution, you see. And really what it is you think of it like a spreadsheet. And so, let's say you have 10,000 people grouped together through the blockchain, and they all post their own individual bond. And basically, it's at its extremely early stage, and it's going through evolution, and it's going to take probably 5 to 10, maybe 5, at the minimum 5 years for it to really even develop. But there's also, it works on a thing called smart contracts, and so, but that's my main question, was to see if it was legal for that to happen in Florida.
Ron,
there's no way you could run a blockchain insurance in Florida under the present law.
Well, and understand that the insurance lobby is probably the strongest lobby in Tallahassee, probably also up in Washington, D.C., and I don't think that the insurance companies are ever going to allow something to supplant them. I always say this, insurance runs the world. I genuinely believe that. And, good luck to finding an alternative way to do it. I mean that sincerely, because I don't always think that insurance is the best way to go. But anyway, that's my answer to your question. And I remember also coming across this with a potential defendant that I had in an accident where a man was hit on a bicycle, and the automobile was possibly owned by a company it was actually a blockchain company based out of Delray Beach, and so I had to look into that a little bit. But anyway, thanks for the call, Ron.
That's interesting. Yeah, but there are some states that, well, I appreciate your call, and thank you very much.
All right. Take care, Ron. Have a great week. Let me talk about this real quick. I've got about 5 minutes left. This is a case out of my Florida Law Weekly, and it is entitled State of Florida versus Freddie Parker, which means it's a criminal case. Somebody had been arrested and was being prosecuted, and that's why these cases are titled that way. This is a traffic stop case, and I wanted to follow up on this just because this is becoming something of an interesting topic for myself and some of my listeners. This is a situation up in Orlando where 2 deputy officers, now they're wearing they call it BWC, body-worn camera. And that was very helpful because everything that the officers testified to was substantiated in the camera footage. But they pulled up behind a vehicle that had very dark tint and was on the roadway, kind of half on the roadway, half off the roadway. They watched an interchange between the driver and somebody on a bike. The officers decided to pull the vehicle over after that. And the officers approached the driver saying, "We're pulling you over because you're parked illegally on the roadway and because we think your tint is too dark. If you weren't aware of that, be careful, because in the state of Florida," good morning, Uncle Mike, I just see you there logged on, tint can be an issue. If your tint is too dark, that is a reason to get pulled over. And then if you're doing illegal things, once you're pulled over for that legitimate reason, then you could be in trouble. And that's exactly what this case stands for, is that at the trial court level, the defendant, which is the guy that got arrested, likely through his lawyer, he filed what's called a motion to suppress. He said that the jury should not be shown the evidence that was taken from my car, which included marijuana and cocaine, because the only reason the cops found that was because they had pulled me over illegally. And the trial court agreed, surprisingly. I thought this was kind of a no-brainer. But the trial court said yes, subjectively, the officers were using those reasons as a farce to investigate and inspect this guy's vehicle. Well, the appellate court disagreed. This is the 5th DCA, which covers basically the center of the state of Florida, around the Orlando area. And the appellate court's opinion says, "We begin with the fundamental principle that the commission of a traffic violation gives law enforcement the right to stop a vehicle." And I talked about this, I think, last week. Maybe you didn't hear it if you're a radio show listener, because I had to run a replay from the Keys. But there is a short list of things that automatically gives officers an opportunity to stop a vehicle, and then stopping the vehicle gives them the right to look in the vehicle. And that's all they did in this case, by the way, is all they had to do was look in the car and they saw it. So this guy was kind of a bonehead for having his stuff out. But a lot of Florida's traffic stop law, what we call stare decisis, is taken from federal law, which is the United States decisions that are applicable around all 50 states. It says, while the trial court found the instant traffic stop invalid for being pretextual, this is a different case. The United States Supreme Court has made clear that the constitutional reasonableness of a traffic stop is not dependent on the subjective motivations of the individual officers involved. Instead, a traffic stop is considered reasonable under the Fourth Amendment of the United States Constitution, where the police have probable cause to believe that a traffic violation has occurred. And so, because the officers walked up, and with their body-worn cameras, they were able to prove, but they said, we're pulling you over for these two valid reasons. The trial court's decision to suppress all of that evidence was overturned. You can imagine how elated this guy was when, at the trial level, at the court, his lawyer calls him up and says, hey, we won, your motion to suppress was granted, and now they can't prosecute you because they have no evidence, you're free. This guy must have been stoked. And then all of a sudden the appellate court comes around and reverses that ruling. It's reversed and remanded. So guess what? So now he's being prosecuted again. Anyway, thanks for listening. Thanks for watching. This is Vastola on the Law. I wish everybody a safe and healthy week. And if you need me, please call me anytime. My number is 833-VASTOLA. That's 833-827-8652. God bless.